Morning.
Morning, guys.
Going
You
Happy
on.
set
almost
that?
happy almost New Year's.
No, you're not supposed to date it. Start over.
Well, we don't have the actual year of the new year though.
That's true.
Yeah, so it's only halfway.
Good to see you guys today.
Right,
What's on
yes.
the agenda?
Agenda, I think we've had a couple of client unfortunate events of needing some assistance from family members. So, speaking to some legal documents to help families manage the financial affairs of the affected person. In this instance, I think we just say spouses of a couple of our client families. So, in my mind, two documents come up. One is a revocable living trust document. The second one would be a financial power of attorney. I guess you can throw a healthcare power of attorney in there as well, but highlighting and concentrating on the financial power of attorney and revocable living trust document. So Joe, why don't you kick this off? You had a client family recently going through this and needing these documents specifically.
Yeah, well, actually, I think the first thing that comes to mind, Greg, when you mentioned it is we commonly think of financial power of attorney in terms of elder care. We have a process kind of as a firm of clients are turning 80. We find a way to say, hey, we want to make sure we have that power of attorney if we don't have one or we don't have a recent one to get that updated. So that's something I know we check on internally in our systems for that. That's the most likely use case, but my power of attorney is sitting in that drawer right there. So watch this recording and find it in there if you need it, because it could be any of us that needs that document because of some physical or mental incapacity that occurs. And what a financial power of attorney does is you're naming the person to make decisions for you if you can. And oftentimes I tell people it's like it might be easier to find the people you don't want making that decision for you than picking the right one. But the act of putting that list, or maybe a list of one plus this backup and another backup, maybe take some people out of your family tree that you would say, "Ooh, I really don't want that person making decisions for me." So the first that came to mind is it could happen anytime. But then, Greg, you're right. Most commonly is, clients in their late 80s, 90s that need more help managing their financial affairs. So ideally, we've done planning with them ahead of time, and they've nominated somebody to serve in that role to help them in a future state when they, have diminished capacity to be able to do that. Doesn't have to be, but it's usually a child that we see in that role to be able to do that. Then the child can help, and the one Greg's talking about is the gentleman's going in to update his wills, and his son felt like it was necessary for him to be part of that process because he just wasn't quite sure if dad was on top of the changes that he was making. So by having that power of attorney in advance, communicating with the attorney, that he was able to go sit in on the meetings and make sure that there wasn't undue pressure on the man who's I think 92 to go in to make changes for that. So the power of attorney can come quickly in the event of accident or illness or something. The most common use I see is just kind of gradual over time. Somebody needing to spot you while you're going in and making decisions about changes in your investments or changes in beneficiaries or different updates that might be out of character for what you've done over the last 10 years.
Yeah, one thing I wanted to mention, you said it could be a gradual process or something, an event that happens. On the gradual process side, um, it is, and you also mentioned diminished capacity, but I wanted to really highlight that it doesn't mean that dementia or Alzheimer's or forgetfulness has set in. It's more as we age, it's harder to make decisions, at least we feel, generally speaking. So having a child or a trusted person help make that decision, or at least know what decisions are being made, is really, really helpful. So in our complex client families, I'm starting to invite the child in on these meetings, and a lot of time they sit there and they listen, but at least they're aware of where financial assets are, how documents are structured, because most of the time, the client doesn't involve their child. They're like, oh yeah, by the way, we got these done, child A, child B. So it is helpful to begin that process whenever they feel comfortable. But us suggesting it is usually part of our process.
I'll put our buddy Tucker on the spot here. Tucker, have you learned the difference between a durable and a springing power of attorney?
Um, I wouldn't say well enough to talk about it.
Well, I'll pick on you because you're the newlywed on the phone call here. So congratulations, first of all, on that in the wedding.
Thank you, I think.
But the part that sometimes people have hesitation on the power of attorney, it's a very powerful document. So I mentioned that sitting next to me. If it's not actually in that drawer and I'm on the call with you, my wife could be out right now emptying my bank accounts, selling our house, selling all the assets I own, because the power of attorney she has is a complete power of attorney. She can act as if she's me. So she can sign documents, she can buy me in contracts, she can do effectively anything as me. That's more common we see in, let's call it a first and only marriage situation. Sometimes people that have life experiences and maybe they've been through a divorce, have been through different traumas in their life, would say, hey, that's a lot of power to give somebody. I want to have what's called a springing power of attorney, which basically means the document doesn't do anything unless there's a spring or an event that occurs to make it enforced. Typically, that's the doctor saying, hey, Joe can't manage his financial affairs. This springing power of attorney is going to go into effect. On one hand, having that extra hurdle kind of defeats the purpose of being able to move quickly if necessary, but it does add an extra protection, if it's warranted or if that's something that we should talk about with the client and with the client's estate planning attorney, whether that's a good fit to be able to do that. Not always the case, but I would say most commonly I see that in situations where it's, second marriage or third marriage, and they've kind of been through life before, different experiences with that, and they want to have that extra protection in place. Some people just don't feel comfortable giving the right to anybody to sign documents in their name. So I have seen spring powers of attorney in first marriage situations before, but that's the difference or the choice made when you're putting that document in place.
And you can also, there's a spot in most attorneys' documents that have specific instructions. So if there's a specific asset that you do not want that person being named to have control over or access to, you can put that in the special instruction section, which I've used very minimal amount of times because it's usually carte blanche, like you said, Joe, when naming somebody and trusting them to make the decision for them. So shifting to the other document I mentioned, the revocable living trust is a document that needs more proactive planning. So you actually need to have the document drafted, signed, executed, and then the assets actually retitled into the revocable trust. And when that happens, you have a trustee that can act basically for that financial asset. And power of attorney would not apply. It would be the revocable trust document that would apply. So when we're discussing who's going to act and what document is going to be primary, it depends on who owns that specific account or piece of real estate or business, etc. So revocable living trust and power of attorney, they need to go hand in hand together, depending on the asset that we're talking about, when controlling or making decisions on them. So revocable trust does put a little more power in the client's hands, because the financial institution does have the right to say no to the financial power of attorney. There's ways to mitigate that, having something new or newly drafted and executed and not stale, so to speak, 5+ years old. The financial institution accepting the financial power of attorney before it's needed. So you present it to the financial institution, say, by the way, this is the power of attorney, naming child A, child B. At that point, you can see whether they're going to accept it or not. They meaning the bank or the investment firm. So that's also helpful to be proactive. So then when you actually need the document, the bank can't say, sorry, it's too old, or it's not our form, or whatever they're going to say.
Yeah, my favorite story here is, does anybody know who owns the Los Angeles Clippers?
Can't say I do.
The Ballmer owns most of
That's
it.
right, Steve Ballmer with Microsoft. But the person who owned it before that, it was the man, the public face was a guy named Donald Sterling. And Donald Sterling got in trouble maybe, I don't know, 8 to 10 years ago, making some unseemly or racist remarks on an audio tape. And obviously that was not taken well by the NBA or the players on the team. So the NBA essentially tried to force him to sell the team, and he said, "I'm not selling the team." But it turned out the team was owned by his revocable trust. So his wife basically stepped in and said, he's not competent. He can't manage his affairs. He doesn't know what he's saying, that kind of thing. So she was able to step in and essentially sell the team to Steve Ballmer, who now owns it. But that was a situation where it was owned in the revocable trust. The individual had diminished capacity. I'm not sure the exact details behind it, but I assume they had doctors involved that agreed to that the individual could not make decisions. So the wife stepped in, was able to sell the team. But Greg, to your point, not every asset can go into that trust. So a question I get all the time is, hey, are we going to move my IRA into the revocable trust? Well, no, we can't do that. That's where the power of attorney comes in. So if we're meeting with a client who has diminished capacity, we have assets typically in a revocable trust. And then we also typically have IRAs or Roth IRAs or assets that can't be moved into the revocable trust. So that's where that power of attorney document comes into play.
Yep, and I want to mention one more thing. Here in Maryland, where we're domiciled, Maryland has a specific, it's called statutory power of attorney. So depending on the state of residence, you might have two financial powers of attorney, one that is general, that kind of covers wherever you are, and then a state specific one that is mandated, well, not mandated, but encouraged, I guess. And it does hold a little bit more power because the state has adopted that specific form if you actually have it. So depending on the state of residence, you should find out if there is a statutory power form available, and then you probably end up with two different documents. So.
Yep. 3 CFP professionals on this call, 0 estate planning attorneys. And, when we do this process, we're working with the estate planning council to draft and create those documents. We're just helping to nudge clients to make sure they have those in place and they've made intentional decisions with appropriate legal counsel to have that.
Yep. Any other questions, or is this enough for the day? Tucker, anything else?
No, well, I'm just kind of thinking through as I'm listening to you guys talk about these topics, just really how it can impact families in general. I mean, when you have, you might have two elderly grandparents or two elderly parents who, one is has Alzheimer's or dementia or diminished capacity, and the other one has been fine over the years. But then as they both continue to get older, um, and they both can quote unquote be considered diminished capacity or forgetful or one dementia, one Alzheimer's, whatever the combination might be. Those documents, it just really, really solidifies how important they are because, someone who might have been counting on their spouse over the years to be the grounded one, I guess you could say, or the one who could stay in the capacity of making those decisions, and they both get to the point where they're unable to. Having those documents, having those provisions that your kids might be able, or other trusted people, whoever that might be, are able to step in and really help, especially in times where either they're aware that they can't, or they're even unaware that they can't, is really powerful. So it just, on top of all the other financial and the planning and other aspects of it, it really just helps an emotional part of the family as well. Peace of mind, I guess you could say. So they're
Right.
they're they're very important.
Very important.
Well
Not
said.
not fun to talk about, but extremely important. So if you haven't gotten them done and you're listening, get on it. And
Right.
on that note, have a great rest of the day, guys.
Hey,
Have a
Greg.
great rest of the day, guys. Thanks, guys.
All right, take care.